So, welcome everyone to the first 3CL seminar. 3CL standing for Center for Corporate and Commercial Law. It's a great pleasure seeing you here. You're starting your academic year, as do we in 3CL. And as you've seen in the email circulated, we have a seminar program. So roughly every 2 or 3 weeks, we meet usually in B16. Today we are in another room. We've got a great lineup of speakers, and it would be great to see you not only today, but also in our next seminars. The next seminar will also benefit from a sandwich lunch being offered just outside B16. Today we had to move our seminar due to your integrity course, so we did this. This cost you lunch. But next time, so half an hour before the seminar, we have a sandwich lunch that everyone is invited to enjoy. Now, I enjoy announcing today's speaker, who is Professor Marc Steinberg. He is the Rupert and Lillian Radford Professor of Law at SMU Dedman School of Law. He is the former director of SMU's Corporate Directors Institute, and he also served in the past as director of the SMU Corporate Counsel Externship Program, the former Senior Associate Dean for Academics, and the former Senior Associate Dean, and as former Senior Associate Dean for Research at the Law School. He has a vast amount of experience. Among those experiences, Marc, you have visited many schools, too many to list them. So actually you are listing your schools not according to name, but according to countries. And of course, the UK is one of those countries. Marc, you've also been retained as an expert witness in several significant matters, including Enron, Martha Stewart, Belnick, and Mark Cuban. Now, today, you're speaking about a book, and I can show this book. Rethinking Securities Law, available in all good libraries, as ours. And you will present on this book, Marc. I'm particularly happy that you present on this book, because it has won awards. Amongst them, it was the winner Best Law Book of 2021 by the American Book Fest Awards. And you focus on the need to rethink the US securities laws. You told me yesterday that this is something that had been growing for a while, and you essentially summarized thoughts that you have developed during many years. And I'm really interested in hearing about it. The way that we run our seminars is usually kind of a 25-minute presentation by our speakers, and after that, there's an opportunity for questions and answers. Please do use this. There are no silly questions, and please feel free to participate. The seminars are there for you and for your participation, so I'm also really looking forward to the discussion after the seminar. Marc, thanks a lot for making your way here. We're very grateful and happy to have you here, and the floor is yours.
I'm honored to be truly one of the great universities and law schools in the world. It's really a privilege for me, and thank you, Professor, for inviting me. I'm very appreciative. I'm also very appreciative of all you being here without lunch. So hopefully I'll make it somewhat worthwhile for you. I'm a professor at SMU in Dallas, Texas. Dallas is a wonderful city to live. We have a very strong international program for any of you thinking about getting another Master's of Law. It is really I think the third city in the United States with the most publicly held companies headquartered there after New York and Los Angeles. And it's really a joy to teach there as well as to live there. A little bit about my career. I've been at this longer than I like to think how old I am. And I began my career, I'd say 4 decades ago with the U.S. Securities Exchange Commission. I was an enforcement attorney and then was in the General Counsel's office. There's a lot to be said, I think, to go with a very good government regulator to get good experience, far more than one is likely to get in a large law firm, at least for the first few years. For example, in the enforcement division, I took, I would say, maybe 20 depositions my very first year on the job. And at least one of those, I recall, was the CEO of a Fortune 500 company. So imagine just being out of law school and taking the deposition of someone who is a CEO of a major company. Needless to say, I learned a lot, and not to say that I was really good at it, but I was a whole lot better after doing it than before I came. And then to be able to use that and go back with that experience with my writing and my consulting and my expert witnessing, it's been a true bonus. So just a word of counseling advice is, even for those of you who wish to go into academia, it will likely make you more valuable to schools having that government experience, if it's a good government agency and you have a good experience. I've been writing about securities laws for many, many years, 4 decades worth, and I was taking a walk one day, and I like to walk most every day, unless I'm playing tennis that day, and sometimes thoughts come to my mind that wouldn't come to my mind otherwise. And I was thinking to myself, it's literally been decades, scores of years, since anyone really looked at the federal securities laws, the U.S. securities laws, talked about what is beneficial about those laws, what are the disadvantages of those laws, how the law should be changed. And then I just said, I'm going to write a book. If people don't like it, they don't like it. It's not going to be the first thing that I may write that they're not going to like. But really, I think it's time that if I'm going to do this task, this is the time. And at that time, COVID hit, and then I had lots of time, and I really kind of buckled down, and within a year and a half, was able to write this book. And basically, the book is to identify the deficiencies that exist under the current U.S. securities law regimen, address the failings, provide recommendations to rectify the weaknesses, and then set forth a thorough framework for remediation in order to prescribe a consistent and sound securities law framework. Now whether my book actually has an impact or not, of course, who knows? I don't think it'll have an impact until the next downturn, although we may not be far away from that. But nonetheless, I think the recommendations are getting a lot of play. I'm honored that the book won the award that it did. And what I'm going to do, and I know you are very bright, obviously you're here, but I understand you haven't taken U.S. securities laws. And if you want a quick summary of the U.S. securities laws, I came out with the 8th edition called Understanding Securities Law. It is a very inexpensive book for a law book. It's $55 U.S., so roughly, 40 pounds or so. And it's available on Amazon and so on. And as far as I'm aware, it's the best-selling reference book in the United States on U.S. securities law. What I'm going to do is talk about some of the very key recommendations I make in the book, explain somewhat what the law is now, and convey to you why I think the change is needed. My understanding is that in the European community, if a fact is material, a company must disclose that fact unless there's justifiable business reason otherwise. Is that also the law here in England? Basically, if a fact is material, it must be disclosed promptly unless there's a justifiable business reason otherwise. I mean, that's the law in Australia, it's the law in the European Union, it's the law in England, it's the law in Canada, but it is not the law in the United States, unbelievably. Basically, the U.S. framework is based upon, with respect to publicly held companies whose stock is traded on a stock exchange, is that in a registered offering, there is the registration statement. And once a company becomes a publicly traded company, then the company must make an annual report, quarterly reports called a 10Q. The annual report is called the 10K. And then in between the periods of the periodic reports, if there is a current event that arises that is required to be disclosed by the SEC, then what is called an 8K must be required to be filed. The loophole is if the company does not speak on the matter, and if the issue is not addressed in an 8K, the company can remain silent for months. Let me give you an example. Let's suppose today we are October 10th, so we're now in the 4th quarter. in the calendar year, and let's suppose the company follows the calendar year, the company receives notice from a major customer that has done business with that company for the last 20 years and accounts for 12% of that company's revenues, that come January 1st, that company, that customer will not be renewing its contract with the company. My understanding is that in nearly all developed markets in the world, that fact must be disclosed. It's certainly material, meaning material that is a fact that would assume importance to a reasonable investor. What investor would not want to know that fact, that come January 1st, the company is going to lose 12% of its revenues that it was having for the last couple of decades? In the United States, that is not required to be disclosed in the 8K. So if the company were to remain silent, the company would not have to disclose that fact until roughly 35 days after the fourth quarter, which would not be until February of next year, which is astounding to me, that a company can basically embargo that information, that secrecy really impairs, I think, the efficient market theory, which I imagine some of you know well, that the market price of a security that is traded in an efficient market reflects all the material information that is in the public domain. And what this does is that it embargoes important information that is not in the public domain, which makes the market price inaccurate about the stock, and even more so, investors are buying and selling that security based upon information that they ought to know. So that's the first example, that I recommend that the U.S. change its law to follow those of the European Union, England, Canada, Australia, that if a fact is material, a fact that would assume importance to a reasonable investor, or a fact that would be price sensitive, would impact the market price, that's the way it is defined in this country, I understand, then it must be disclosed unless the company has a justifiable business reason for non-disclosure, such as it's in the midst of very sensitive merger negotiations. And that if we're to disclose these negotiations, then the deal would be impaired. So that's the first recommendation. The second recommendation is that if you see these prospectuses from U.S. companies and these annual reports, they now run over 100 pages, 150 pages. If you look at management compensation with all the tables and all the disclosure, that item alone can run 30 or 40 printed pages. Who other than institutional investors, active investors, will have the time or the attention span to read this? There's clearly information overload, even for sophisticated investors. My recommendation is very simple, but yet the SEC declines to mandate it. And that is that a summary be required at the forepart of the disclosure document, such as not to exceed 10 pages, whereby you and I can look at those 10 pages, see what's really key, and then make our investment decisions. Of course, not all the information can be included in the summary as is contained in the complete document. Perhaps there's a concern about liability. But if the focus of the law is to enhance investor understanding so that informed business decisions can be made, then a summary is necessitated. But yet the U.S. SEC refuses to require one. Let me go to private offerings. I'm going to hit upon just a few of these. In the last chapter, I make all the recommendations, and there are about 125 of them. So I was really amazed about the number of recommendations I made because I had no idea. What happens is that I play tennis with some of my students. It's all anonymous grading, so if they beat me, I can't take it out on them. And I was playing tennis with actually one of my former students, and I was saying, Corey, I'm at the end, I'm kind of tired, I'm thinking about writing a short conclusion, maybe 3 to 5 pages, just be done with the book. or I can go back and just try to weed out all the recommendations and put them all in one place in the final chapter. And he says, I think you should definitely go back and put all the recommendations together. I said, okay. Well, to my surprise, it didn't take that long. And if I were to guess how many I had before I started doing them, I would have guessed maybe 30. And I ended up having over 125. He got a free copy of the book, by the way. So I'm just going to highlight some of the few that hopefully will be more understandable. There are private offerings. I'm sure where the countries you're coming from, there are private offerings that are not required to be registered, and many of these offerings are made by privately held companies that are not in the public reporting framework. There's a real problem with the U.S. securities regulation because some of these companies are making private offerings after private offerings, and now there are scores of what are called unicorns, companies that have over $1 billion in assets. And yet these companies are beyond the reach of mandatory disclosure. That has got to be resolved in some way to bring some sort of mandatory disclosure with companies having such an impact upon the economy and on investors. With these type of exempt offerings in general, the basic rule is that if an offering is made to accredited investors, then there's no mandated disclosure at all. It is a matter of negotiation, and what is set forth is only subject to the anti-fraud rules. What happened in 1982 when the SEC adopted this rule is that for individuals, accredited investors were defined as individuals who have $1 million net worth or annual income of $200,000 per year in the past 2 years and expect to make $200,000 during the current year, or $300,000 joint income with one spouse or one spousal equivalent. Congress legislated, and now the $1 million net worth level excludes one's primary residence. Well, what has happened is that although the SEC has made many changes to enhance capital formation, and a number of these have not adversely impacted investors, the SEC since 1982, so we're talking about over 40 years, has refused to raise the accredited investor level. So we're talking about individuals, for example, individuals, for example, that work their livelihood, that are retirees, that happen to have a pension worth $600,000 or $700,000 U.S. through their 35, 40 years of working in the factories, that may have another $300,000 in home furnishings and a vacation home or perhaps their automobiles. They will qualify as accredited investors even if they know nothing about the securities markets. This is an irrebuttable presumption that roughly 14% of U.S. households qualify as accredited investors. The SEC refuses to increase this level, even under a Democratic pro-investor administration. The Commission has refused to do this. And I find it absolutely uncalled for and unacceptable. Why? Because we have fraud. And fraudsters engage in a number of these offerings, and we have elder fraud. I'm sure that's a problem in this country as well. And these individuals can go ahead and be talked into these investments as, quote, accredited investors and basically have their life savings gone. I suggest to require for one to be an accredited investor, one must him or herself or itself have adequate financial sophistication or be advised by someone who is, and then with respect to net worth, that would be indexed from $1982 to today, that both those would be required. Let me talk about insider trading. The U.S. securities laws are followed by many countries, but I've just named a few which the U.S. securities laws are unacceptable and other countries have not implemented them. Another is with respect to insider trading. Rather than adopt the parity of information rule or the access rule, which other countries have adopted throughout the world, such as if one is in possession of material non-public information, one cannot trade on that information before that information is disseminated and made known to the public. The U.S. bases bases insider trading on fiduciary duty concepts, that one must have a relationship of trust and confidence or fiduciary duty to investors on the other side of the trade or to the source of the information in order to be held liable under the main anti-fraud provision of the federal securities laws, Section 10B. I don't understand this because what it does is permit individuals to engage in insider trading when they clearly have inappropriate access and possession of material non-public information. I therefore suggest that the U.S. markets change to the access approach. And even more so, what happens is that under a provision called Section 16 of the Securities Exchange Act and SEC rules thereunder, when insiders trade, namely directors, officers, and shareholders who own more than 10% of an equity security, they must disclose their trade 2 days after they trade. Now, of course, if they trade on material non-public information, then they would have violated the law because they do owe a duty. But let's assume they do not trade on material non-public information. Even if we assume that, we also know that insiders always know more information than we do as shareholders. After all, they're officers, they're directors, they're privy to information every day, which we are not. That creates an unfair playing field, plus insider trading sends a signal to the marketplace, either optimistic or negatively, especially if it's done in large amounts of stock. My point is that these individuals are fiduciaries. Why should they be at the front of the queue? They owe a duty to the corporation. They owe a duty to shareholders. Why are they going first? My proposal is that these individuals must file a form that they intend to trade, and then after they file that form and it's publicly known, then they can engage in their trade. But it must wait until that time. Let me talk about compensation, management compensation in the United States. In 1989, the ratio of CEO pay to the average worker, to the median worker, was 61 to 1 in 1989. Today, well, this was 2022 figures, it's now 299 times differential. In other words, the largest differential in the world. That we can have CEOs making $25 million US a year, while the median employee is making $15,000 US per year. What can be done about that? I have two proposals. One is that under US law now, as enacted in the Dodd-Frank Act of 2010, shareholders have a permissive vote with respect to management pay. In other words, it is not a binding vote. It is simply shareholders expressing their opinion whether the pay is excessive. My recommendation is to make this vote binding. That in order for the CEOs and other high-level executives to be paid this type of money, shareholders must approve this compensation package. My other proposal, which I'll be surprised will ever be adopted, is that there be a labor representative on the board of directors, and that labor representative sit on the compensation committee. In other words, the compensation committee, even though comprised of independent directors, these individuals have a structural bias with the other directors. They don't think a CEO making 12 or 15 or 20 or $30 million is out of the ordinary. I think the presence of a labor representative representing the interests of the employees who are on the assembly lines and so on will bring a view of moderation to committee meetings and will have a positive effect. So that's my recommendation with respect to that. In the U.S., surprisingly, CEOs of publicly held companies usually are chairs of boards. Many of the Fortune 500 companies have changed to a non-executive chair. But even with respect to the Fortune 500 companies, they're in a minority. My last figure I saw is about 38% of Fortune 500 companies have non-executive chairs. This is unlike many other developed markets in the world. What is the problem with this? The problem is the board is supposed to monitor management. When you have a CEO who is chair of the board, that certainly impedes that type of monitoring. Also, for those who have practiced, you know that insiders control the flow of information to the board. And not surprisingly, the insiders are reluctant to disclose to the board adverse information. And we look at a number of the frauds that have occurred. All too frequently, the outside directors, the independent directors, are clueless with respect to what was going on. What I think would help the situation would be to have an independent chair who would have better access to the internal documents, and in addition to that, is to have a committee formed, a disclosure committee formed, solely of independent directors with their own legal counsel to ensure that the outside directors have adequate access to internal information and to enhance their due diligence obligations. How much more time do I have? Okay, great. Let me talk about the SEC. The SEC is still a great agency, but its conduct with respect to regulation is questionable. And what do I mean by that? Now, if you read the Wall Street Journal, which I get every day, it's a wonderful paper. And in fact, my opinion is that whether I agree with the editorials or I don't, the reporting in the Wall Street Journal is the most objective reporting, at least in the U.S., that I know of. But in any event, I'm not here speaking on behalf of the Wall Street Journal, but the SEC simply has not used the enforcement tools that it clearly has. What is one huge example that I wrote an article about this, it's in 2 of my books, and I've had zero impact. And that is, there is a provision under the federal securities laws called the control person provision. And the control person provision says that if a controlled person engages in misconduct, the person who controls that person is equally as liable unless that person who's the controller shows good faith. So in other words, there's a primary violation by the company. The CEO is a control person. The chair of the board of directors is a control person. That person is liable if the company makes a false disclosure, materially false disclosure, with the requisite state of mind. The company does that, then the CEO, the chair of the board, if it's an accounting issue, the chair of the audit committee, these are control persons. They're equally as liable unless they establish good faith. If you look at U.S. securities class actions, and even though there are issues with U.S. securities laws, how arduous it may be for plaintiffs, and also with respect to insider trading, the higher standards, there's no question, in my opinion, that there's much greater enforcement of the securities laws in the U.S. than any other country in the world. Look at the litigation activity, both privately and by the SEC. So although the U.S. laws are not perfect, if you look at their actual implementation, they're implemented in practice far more than other countries' laws that are by its statutes and their rules more rigorous than the U.S. But my point with the control person provision, and I'll end with this, is that if you look at the class actions in the United States, the vast majority of these class actions invoke the control person provision. Why not? You are a securities plaintiff's lawyer. You are suing for $50 million in damages. The company has made a materially false statement. You've got to show intent in the secondary markets in the U.S. that it was made with intent. You make the allegations with sufficient particularity. Well, then who else is liable? Of course, the person who controlled the company. Who controls the company? The CEO, perhaps the CFO, perhaps the chair of the board, perhaps the chair of the audit committee. You, of course, bring these individuals into the lawsuit as a matter of course. What's my point? The SEC does not use this provision. So in other words, we have the government agency of the United States, who is viewed as a great enforcer, that has a statutory remedy that has been provided by Congress, that is used by the private bar with regularity, and the SEC refuses to implement that statutory mechanism to hold insiders liable. In other words, what we're seeing today, if you look at these enforcement actions, is the Commission is bringing enforcement action after enforcement action against publicly held company, and they're imposing hefty monetary penalties with rarely any sanction at all imposed against a director or officer. What's the consequence in my view? Unless there's a fair fund that's established to provide injured investors recompense with respect to that injury, many of these fines are going directly to the U.S. Treasury. I don't find that acceptable. You and I, if we're shareholders of these companies, we're paying for this culpable conduct by insiders. It seems to me these kind of hefty $20 million, $50 million, $100 million fines against publicly held companies while not touching those who created the problem is a real catastrophe and problem underlying the U.S. securities laws. And I'll stop there and be happy to take any questions.